Mark Blankenship is our presenter here. He is next up navigating the uncharted territories of AI, ensuring that these powerful tools remain our trusty steeds and not rogue stallions. As the Director of Risk Management for Willis Tower Watson A&E, Mark uses his 25 years of experience in A&E professional liability, underwriting, and brokerage to provide risk management advice and educational presentation to architectural, engineering, and construction clients. Mark, hand it over to you. Thank you. Thank you.
Hello, everybody. I'm Mark Blankenship. Hope you can hear me well. So this last weekend, I was at home looking at a tutorial on how to use Midjourney to create visual representations of buildings using artificial intelligence. It's true, I'm fun at parties. Anyway, what I discovered was in this tutorial, it said, so if you would like to create a building in the style of this famous architect, who happens to be one of our clients, then you just select the drop down, the architect, boom, shakalaka, there is a building in the style of Mr. Famous Architect. Well, I wasn't aware that this was happening, so I know the general counsel for this famous architect, and I called him up and I said, are you licensing your designs now to AI? And he said, not that I'm aware of. Welcome to the world of artificial intelligence. And let me ask you, how would you feel if you found out that artificial intelligence was taking your design and giving it to clients? What are you going to do when your client comes to you and said, oh, by the way, I've already done the design here? Or better yet, when they come to you and say, here's a building in the style of Famous Architect, build this, will you please? What are you going to do? Well, artificial intelligence, it's here. Let's talk about it, shall we? I'm with Willis A&E. We specialize in architects and engineers. That's really all we do. As a Director of Risk Management, I'm a consultant, and that's our website. What are we going to talk about today? Well, we'll talk briefly about the opportunities presented by AI. Who here is using AI? Anybody? A bunch of folks. All right, good. We'll survey just a couple of the current applications. We're going to mostly talk about concerns, though, and take a look at the current legal environment and get some guidance, hopefully, from the legal cases that have been decided or in progress right now, and hopefully come up with some recommendations at the end of all this. Artificial intelligence, what are the opportunities? Well, there's lots of them, right? Robotics, that's probably the most mature and well-established area of AI today. Manufacturing clients can use AI to analyze production data, identify patterns to improve manufacturing processes and effectiveness. Logistics, supply chain management can utilize AI to upgrade transportation routes, foresee demands, oversee stock, right? Autonomous systems, such as self-driving systems and robots, can use AI to navigate, make decisions, and respond to changing conditions. By the way, question, who here trusts the automatic car more than the humans? Anybody? Me? We're still trusting the humans? Really? Okay. Not me, but that's all right. Civil engineers, right? Energy sector engineers, chemical engineers, all of these folks have AI applications, right? And we could add a new discipline. We could add a new discipline now, prompt engineering, right? That's a thing. That's a thing. So generative design already provides, feasible options, but it's really not being used yet for complete structures. So when I think about, text to design, that's happening. That's Midjourney, but it doesn't really give us fully fleshed out problems. And the problem today is we have the plausible sounding but nonsensical output that's likely going to plague attempts at designing complete buildings using AI because of what we call the hallucination problem, right? Fun story. This involves any lawyers in the room before I start here? No? Good. Okay. I can slam on lawyers then. There was a lawyer, in case you hadn't heard, in New York who decided to use ChatGPT to write a brief. And here's my argument ChatGPT, write me a brief. And ChatGPT turned out a beautiful brief. The problem was, all of the cases were made up, right? And the lawyer didn't bother to research these, but he turned them in, submitted it as a filed document, and the judge started looking at it, and the opposing counsel's like, what? So that was embarrassing, but that illustrates the problem of hallucinations, right? Sometimes the computer can imagine things that really can't be built or don't exist. AI, I'm using AI. I'm using AI to review contracts, right? And so what I find is it's a useful tool because in reviewing contracts for insurability or liability issues, I spend about half my time, or at least I used to, looking at stuff that's not impactful, that doesn't matter, that I don't care about. And then I would spend the rest of my time, fixing the problems. Artificial intelligence takes me right to the problems, gives me suggested prompts, which I will modify or delete. So I look at it as an efficiency tool. I think that's where we are today with design tools as well. So the commonalities then with all of these tools is they have the ability to process and analyze large amounts of data in very short amount of time. And they have the ability in many cases to make predictions. And our job right now as users is to write the right prompts and to tweak it in this process known as prompt engineering until we get the output that we want. Maybe it's perfect, but maybe not. So what are some of the current applications? Well, this is just a sample. I think it's a representative sample of what's out there. BST looks at multiple digital signals and applies the AI and machine learning to predict project outcomes. This could be very useful if you're trying to stay on budget, stay on schedule. This might be a useful tool for you. Civil's AI automates some critical procedures such as structural analysis, material selection, and estimating. Also very useful. Autodesk Civil 3D generates scripts that automate repetitive and complex tasks. That's a lot like what I'm doing with contract review. The aforementioned Midjourney generates images from natural language descriptions called prompts, and Photor allows the use of text, images, blueprints as prompts for image generation. So it seems like this is all exploding so suddenly, right? But actually, it's been a long time coming. When I was at Michigan State in the late 70s, there were already people working on language recognition software all back then. My very first architect and engineering claim that I handled over 25 years ago was a result of a defect in a computer program that did not consider thermal expansion here in Chicago. And boy, do we have some extremes here from very cold to very hot. And had the city of Chicago not required hand calculations at that time, a certain educational facility would have been built so that the windows probably would have fallen out on the students in a very hot day one day. So it's been coming, but now it's growing exponentially. So what are our concerns? I think these are our big three. Intellectual property and ownership. Determining ownership of AI-generated work can be challenging. You may need to address questions about who owns the AI-generated content, the inventions, or the algorithms. Liability and accountability, this is a big ticket item right here. AI, as these systems become more autonomous, questions will arise about who is responsible if an AI system causes harm or makes a mistake. You might face liability issues if your AI systems malfunction, produce incorrect results, or cause harm to individuals or property. Let's suppose, anybody here have a Lexus? Yeah, no? I was in a Lexus as an Uber passenger, and I noticed it had self-driving capability. That's a $19,000 upgrade, I am told. But what if you are relaxing in your Lexus and your self-driving Lexus hits somebody? Who's responsible? Is it you? Is it Lexus? Is it the developer of the software? These are some interesting questions. Then data privacy and security. AI often requires large amounts of data to function effectively. And so processing and storage of data must comply with legal requirements, and there are a lot of them regarding data privacy. And mishandling of sensitive data could lead to significant legal and regulatory consequences. Bias and discrimination is possible. If you're using AI in a hiring algorithm, that might favor the class who is favored historically, right, as an outcome. Regulation and compliance. Depending on the industry and application, engineers working with AI need to adhere to specific regulations. This could include compliance with standards, certifications, or industry-specific guidelines for safety and performance. And then as far as transparency and explainability, as these AI systems become more complex, there's a growing need for transparency and explainability. Legal challenges can arise if decisions made by AI are not understandable or explainable, particularly in highly regulated industries like finance or healthcare. But that's not all, folks. We also have ethical considerations, right? They can have legal implications. We might face ethical challenges if AI systems engage in unethical behavior, violate human rights, or otherwise conflict with widely accepted norms. Consumer protections. Engineers developing AI-driven products or services need to consider consumer protection laws and their regulations. This could include issues related to product liability, warranties, or consumer rights, and international and cross-border issues. As AI technology often crosses international borders, engineers need to consider issues related to data sovereignty, cross-border data transfers, and compliance with different legal frameworks in various jurisdictions. The United States does have some restrictions on cross-border transfer of technology that could be used for military applications, I think rightfully so. Finally, antitrust. AI is now being used by many businesses to engage in what is potentially anti-competitive behavior in violation of applicable law, including the Sherman Antitrust Act and the Clayton Antitrust Act, and comparable state statutes. Specifically, AI could be used to facilitate price-fixing arrangements among competitors, as well as reach anti-competitive agreements with other AI systems. In fact, there's already been a lawsuit on this, alleging that some AI did, in fact, conspire with other AI to fix prices in the Amazon marketplace. And lastly, some people, there's going to be winners and losers in this transaction, right? If what we're looking at is efficiency gains, that suggests that some people are going to lose their jobs in this transaction. And I will tell you another story from my personal history. My mom was a computer programmer, and back in the early 90s, she went to work for Bankers Life and Casualty. Now, being like me, she was not an early riser. She liked to arrive at 9:30. She had to park at the back of the lot. Now, what her job was to create programs that would automate the letters that Bankers Life and Casualty would send to their policyholders all the time. And so they had an army of typists doing this work. And as she progressed in her project, she was able to park closer and closer to the building when she arrived at 9 or 9:30 or whenever she showed up. So, but for us today, if we are, going to automate tasks and be laying off employees because now we can do things faster, more efficiently, and with fewer employees, we have to comply with the terms of the Worker Adjustment and Retraining Act, the so-called WARN Act, and comparable state statutes, related to layoffs. So let's talk a little bit about the legal environment then, starting with the Communications and Decency Act. Basically what this act says is that your internet service provider is not responsible for anything, right? So we can just remove them from the equation right now. It promotes free speech, okay, whatever. But if you want to know what's going on, you might start with taking a look at what the National Conference of State Legislatures is doing. And there's a surprising amount of legislation that's happening, that's being developed. In this year, so far, at least 25 states and Puerto Rico and the District of Columbia have introduced artificial intelligence bills. And 14 states have already passed such bills. And maybe not surprisingly, California is the most active state in that regard, although Illinois has some measures too. In fact, Illinois was passed one of the first major AI pieces of legislation, which was the Biometrics Act, right? Is everybody aware of that? Yeah, right? So, Facebook has been sued in multiple class actions for violations of this Biometric Act that we have in Illinois. So, but just this year, Illinois has passed a few acts. The Human Rights Act, that an employer may not use predictive analytics, who's using predictive analytics, may not use zip code as a proxy for race. So this is kind of an anti-discrimination statute. Kind of makes sense. This one is fun, though. The Anti-Click Gambling Analytics Act prohibits any degenerate gamblers in here. You should be happy to know that they're trying to level the playing field a little bit, and that casinos may not collect your data with the intent of predicting how you will bet next. So you could go be a Bears fan. Good luck with that. Then we have also the Hospital Diagnostic Certification Act. Diagnostic algorithms must be certified by the Department of Public Health and the Department of Innovation and Technology. So those are a few of the acts that have just been passed this year in Illinois. And there's another one. Now, I don't know, has anybody ever had their interview videotaped? But apparently people do this. And so Illinois has passed the Artificial Intelligence Video Interview Act. So if you intend to run that video interview through an AI system to measure the performance of the applicant, first you must notify the applicant that you're going to do it. You must provide information to that applicant on how the AI is going to work, maybe allow them to prep, maybe put on a little makeup, I don't know what they're looking for, and obtain consent to being evaluated using AI. So that's another employment practices related act that's on the books now here in Illinois. But looking at from a national perspective, right now we don't have any overarching national legislation on AI. But we're thinking about it, okay? The National Institute of Standards and Technology is holding discussions to develop federal standards for the creation of reliable, robust, and trustworthy AI system. So if you have strong opinions, you want to be part of shaping the future, you might voice your concerns to the National Institute of Standards and Technology. Because, in the absence of legislation, it's the software licensing agreements are going to control the legal environment. Anybody recognize this piece? How do we like it? On a scale of, thumbs up, thumbs down? Meh. This is artificial intelligence generated art. This is called a recent entrance to paradise. And I can show it to you and I can publish it on my Facebook page because this guy couldn't get a copyright for that. That's right, folks. It turns out that purely AI generated content is not copyrightable. It requires a human. And it's only human created content that is copyrightable. So this could not be registered because it was made without any creative contribution from a human actor. Yeah, I believe that. So the decision is currently being appealed in the case of Thaler versus Perlmutter. In case you wonder, who the hell's Perlmutter? That's the chief of the Copyright Office, okay? And because the Copyright Act provides copyright protection only for works of authorship. I think we imply the word human before authorship. And so now there's a public inquiry by the Copyright Office as well as to how the law should apply to the use of copyrighted works in AI training and the resulting treatment of outputs. Now what I think is funny is for all the effort that this guy put into training the algorithms to create this, He could have painted that damn picture himself a lot easier and probably a lot better. But okay, so copyrights. Guidance for copywriters. The Copyright Office will consider whether your AI contributions are a result of mechanical reproduction or the author's new and mental conception to which the author gave visible form. When AI technology receives solely a prompt, and the AI determines the expression of the elements as the output, then the generated material is not the product of human authorship, is not subject to copyright. So what matters then is the extent to which the human had creative control over the work's expression and actually formed the traditional elements of authorship. So that's where we are today on copyrights. Let's talk about some litigation that's currently pending, shall we? For instance, Getty Images, they're suing Stability AI in the great state of Delaware, alleging misuse of copyright in images. And they admit that the AI company copied more than 12 million copyrighted images and their associated metadata without getting anybody's permission. Takes us back to my original question, right? What if they took your stuff? More litigation. Anderson versus Stability. This is a class action filed in California by 3 artists and against Stability AI, a company out of London that co-developed Stable Diffusion software. They're also suing Midjourney, who we talked about, San Francisco-based startup that uses Stable Diffusion to power its text-based image creation tool. And they're also suing DeviantArt, which now offers its own Stable Diffusion-powered generator called DreamUp. How is that going, you might ask? Well, the suit claims that Stable Diffusion was trained on billions of images scraped from the internet without consent, including images owned by this trio of artists. And the CEO of Midjourney, Mr. David Holtz, admitted that the data set that the company trained its AI model was just a big scrape of the internet, right? And the company had not sought the consent from anybody who owned or created that art. Well, it hasn't been decided yet, but we have a clue. The Judge Orrick, has stated, yeah, I don't think the claim regarding the output of images is plausible at the moment because there's no substantial similarity between the images created by the artists and the images created by the AI image generator. So if you can imagine, taking a big scrape of the internet, they probably stole your stuff, but how are you going to prove it? There's going to be one little detail in the grand scheme of things. Is that going to be enough for you to sustain a copyright infringement claim? I don't know. First, you're going to have to carefully examine the output and see if you can find your elements included in there somewhere. So I don't think our trio of artists in California are going to prevail. There's another case. This involves code. And this is the Savieri law firm is suing Microsoft, GitHub, and OpenAI, the creator of ChatGPT, for making a Copilot. And what Copilot does is it's an automatic code generator trained on existing code available online but they didn't seek, again, permission from anybody who wrote it. That case is currently pending, so we're kind of waiting on some guidance from that case. There's another one. But I don't think it's going to go well, and this is why. Google versus Oracle, Battle of the Titans. And Oracle originated the suit saying that application programming interfaces, or APIs, were copyrightable, and they wanted $8.8 billion in damages. Shoot high. And the Supreme Court ruled 6-2 against them, saying that Google's use of the Java APIs fell within the 4 factors of fair use. Like, what? How is that fair use? What is fair use? Let's talk about fair use. There's four determining characteristics. Four questions that must be answered. We all know that fair use is something that professors can avail themselves of, right? I can quote things and I can show you samples for educational purposes. That's considered fair use generally. But the four questions are: what is the purpose and character of the use? Is it commercial in nature, or is it for nonprofit or educational purposes? What is the nature of the copyrighted work? What is the amount of the copyrighted work used in relation to the work as a whole? And what is the effect of the use of that copyrighted work on the potential market value of the copyrighted work? Now, even if you answer all these questions, I don't think you get a clear yes or no. Right? But anyway, borrowing stuff, copyrighted materials, you can get away with it if you can prove it's a fair use and you tip the scale on these four questions. In the past, and as we saw, Google was able to prove that their use of Oracle's programming was fair use. I don't know how they did. They must have had great lawyers. That's all I can say. In the past, scraping images or other content for training data sets has been considered fair use under U.S. copyright law. So I expect this trend to just grab stuff off the internet is going to continue. But in 2016, the Supreme Court refused an appeal from authors who sued Google for scanning more than 20 million copyrighted books and indexing them for the Google Books website. So the Supreme Court has definitely enforced fair use against a number of major companies. So what's our guidance for copyright applicants? Well, you do have a duty to disclose the use of AI-generated content in a work submitted for registration and provide a brief description of the human author's contributions to the work. And it's just saying that you wrote the software that created the AI is probably not going to get you there. Applicants should not list an AI technology or the company that provided it as an author, because only humans can create copyrightable material. And AI content that is more than de minimis should be explicitly excluded from the application. It sounds a little bit confusing, but consider another case where an author of a children's book, she wrote the story, and she used Midjourney to do the graphics. Came out pretty good. She was able to copyright her text and the story. She was not able to copyright the images that went into the book. Applicants who are unsure of how to fill out the application may simply provide a general statement that a work contains AI-generated material, and the Copyright Office will allegedly follow up with you to determine what portion of your work is copyrightable. Now let's talk about some big questions and the professional standard of care. How many professional licenses in the room here? Yeah, we've got a bunch, right? So you all know your legal liability, your legal obligation is to meet the professional standard of care. That is defined as that degree of skill demonstrated by similarly situated professionals practicing in the community at the time services are offered. So I think most of your competitors are using computers and software. I don't see too many blueprint tables anymore. But that's your legal obligation. So to what extent can you delegate this work down to a computer? That's an open question at this point. Right now, I think we're good with the tools that are currently available and the way they're being used. It's not that much different from the tools that you have been using, the CAD tools that you have been using all along. Ultimately, the ceiling professional maintains responsibility for the output, and I do believe the focus is on the output and how well that performs, rather than how the documents were created. I do have one word of warning, which is bad. We have a saying in insurance and law, which is bad facts make bad law. So if there is ever a massive failure or a collapse or something, and that can be shown to have arisen from AI generate content that was not caught by a human before being sealed, then we might expect some legislation limiting the use of AI. But right now, we haven't had that case, and we don't have that law. But it does beg the question, if you're doing extensive generation of design documentation by computer, are you fulfilling your professional obligation? Is this created under the direct supervision of the licensed professional? That's a question you should be prepared to answer. And then who is responsible if there is an error in the output and it gets incorporated into the design docs? Well, we got a couple options here. It could be the person operating the AI system. Could be the manufacturer of the AI system. Could be the developer of the AI software. But I think it's going to ultimately fall to the person operating the AI system. It's going to be the licensed professional, especially when you consider the license agreement that you click through when you open the software. I'm sure it has limitation of liability language. It says that you are responsible and probably says that you're going to indemnify the software company if anybody goes after them. So, professional liability is a personal responsibility, but if you're selling your AI, if you create and sell AI, you are possibly moving into the realm of product liability. Or if your AI is incorporated into a product, meaning something that's mass-produced and distributed, there are potential theories of liability that you could be exposed to. Most common would be negligence. And in a product's case, privity of contract is not necessarily required. In other words, there doesn't have to be an agreement or any kind of contract between the user of the product and the designer of the software for the injured party to sustain a claim. And if a product is unreasonably dangerous, it can expose the seller, everybody in the chain, to strict liability. What strict liability means is that the negligence of the end user can't be used against them. For example, back in the day, I used to handle claims for Kmart, right? Well, that was fun. And so they sold a table saw to some fellow down in the South who got drunk on a Saturday night and removed the guard from his table saw, proceeded to saw his thumb off. Well, unfortunately, because you could remove the guard, that made it an unreasonably dangerous product, and I couldn't use the fact of him, being drunk and stupid against him. That's what strict liability means. You could also have a breach of warranty, and warranties are typically spelled out in a purchase agreement. Usually warranties operate to limit, not expand, the general legal duties. That's kind of a fun fact. So let's talk about AI and product liability cases, shall we? So there is the case of Cruz versus Talmadge, and this was a bit of a surprise when I read about this. So this is a GPS case, right? So that's one of the early examples of artificial intelligence. But the plaintiffs were injured when the bus they were riding in struck an overpass that was too low for the bus to clear. And they sued the manufacturers of the GPS devices. Apparently the bus driver was using 2 devices because I don't know why. And the theory of the case was that the device did not lead the driver to an alternate route to avoid the low overpass. Now, I don't know how your GPS is supposed to know how tall your vehicle is, but that was the theory of the case. And the plaintiffs said that the accident was foreseeable because this had happened in previous incidents and the manufacturer was aware of it. And they prevailed. They got a verdict. So that was an adverse case. There was another case, similar, Nilsson versus General Motors. It was a GM Bolt. This was an early autonomous vehicle, kind of like your Tesla. And it swerved and hit a motorcyclist. Now, I don't know why it swerved, but AI might be, confronted to make that snap decision like we have to make from time to time as drivers. Do I swerve into the next lane to avoid that hazard in front? And anyway, it made a decision, and there was a driver, what they called a backup driver in the vehicle. And he was present, may or may not have been awake, but he didn't correct the car. He didn't do anything to avoid the accident. And then the plaintiff sued only GM, which I thought was an interesting move on the plaintiff's part, alleging that the vehicle negligently drove itself. Well, GM admitted that they had to meet the negligence standard, which was a surprise because nobody ever admits anything in court, usually, and they settled. So we don't know how that case would have gone had it went to a verdict, but I think the motorcyclist probably would have prevailed. So for now, then, we must leave it to the courts to decide how to apply the reasonable care standard to a non-human actor. Right? It might work out to be a little higher of a standard because we expect more from machines. We don't expect them to make mistakes. But where an AI product acts autonomously, the court must establish also how foreseeability is determined. If we're using something for a novel purpose, it's hard to foresee how it's going to work out. And if the products themselves can be held liable, then it's ambiguous who's ultimately responsible for payment, right? If your car caused an accident, who should pay? Tesla? You? Probably Allstate, but anyway. Okay, so future regulation approaches. It could be in the future that different industries would develop their own regulations for the use of AI based on the specific needs of that industry. We could see a regulation of AI through the development of sector-wide regulations, or we could see regulation through the development of general AI regulations. I think it's coming. The question is, what form is it going to take? For you, now I mentioned previously bad facts make bad law, and they also make bad case outcomes. So if you are using AI in your design and there's a problem and you wind up in a lawsuit, do you want the discovery phase to be the time when your client learns that you were using AI? Do you think that might be used against you by the plaintiff's lawyer saying, you misled us, you withheld the fact that you were using AI to do things cheaper so you would make more money and all at the risk of my client? Oh, I could see that argument. So I would urge, if you're going to use AI in your design effort, disclose it. Make it a competitive advantage. I think it's an efficiency tool. It's going to allow you to work smarter and faster. I think that there's lots of good reasons to disclose it, the use of AI, if you are in fact using it. We can allow companies to train models on their own servers without sharing data with other people, optimizing the benefits of large in-house data sets and intellectual property. So this I think is the safest path. If you work for a large enough company that you have a large data set, you can start to develop your own AI. And so then you are controlling the inputs, you've got high quality inputs, and you're not concerned about copyright issues, right? It's all your stuff. So that's one model. I think that's the safest path forward. There's still a long way to go, though, before AI models are used for safety critical applications in engineering. And areas with a bit more margin for error, such as demand forecasting or quality assurance, are probably better suited for these applications. So our recommendations: collaborate with the experts who specialize in technology, intellectual property, and data privacy issues, right? It's a complicated world out there, and I mean, just being good at engineering is quite an accomplishment in and of itself. It's hard to be really thorough in the law without being a lawyer. Support AI-tailored regulations made by lawmakers with the input of a wide range of stakeholders, as opposed to the internal self-policing policies that AI companies would probably prefer. We've seen what happens when industry polices itself, right? It usually is not a good outcome for the public. We'll spend a little bit of time thinking about those license agreements that are really the controlling documents right now. I can tell you for sure, whenever there's a claim or a lawsuit, the first thing the lawyer wants to see, the first thing the judge wants to see is, show me the contract. So that's the license agreement. If you, as a licensor, you would like to have to make sure that the software company, I'm sorry, you're the licensee, but you want to make sure the licensor has the right to enter into the agreement and license the AI, including all the elements that should be in their representations and warranties to you. As a licensee, you would like a warranty and representation that the licensor software does not infringe on the property rights of third parties, because that litigation is out there. So you would like the software company to represent that to you. And the licensor should represent and warrant that it is the owner of the licensed AI and that it is the responsible, as the user, you would be responsible for the creation of the AI. So we want a specific representation and warranty that the licensor has complied with all applicable data privacy laws and regulations. Most licensors will seek to include a limited warranty addressing malfunction and the corresponding loss or injury with remedies that are exclusive in nature. This is where you really want to read the fine print. If you're using AI, I'm just willing to bet that they're not going to be responsible for accidents or injuries. In fact, they'll probably ask for indemnification for you should they be sued for the on the outputs. And we want to seek, but we do want to seek a representation and warranty from the licensor addressing how that AI was trained and the source of the data used in that training. I think you have a right to know. Where's the information coming from? Indemnification, that's a big old word that just means reimburse, to pay for damages. But indemnification will typically cover any breach of the agreement, including the representations and warranties regarding non-infringement and functionality. That's what you want from your software provider. Liability for intellectual property infringement is a substantial risk, and probably in the limitation liability that the software company is imposing on you, you would like an exception that if their tool infringes on somebody else's copyrights and you used it without knowing this, they should ultimately be responsible. They shouldn't be standing behind a limitation of liability. And if you want to be advanced class, forward thinker, ask that they escrow the underlying data set and source code of the AI tool in case the AI company becomes insolvent, bankrupt, goes out of business. You still want to use the tool. You have to have access to the code and the data set that it was using. And this is our last slide here. The European Commission is a little bit ahead of us. In 2022, they have established goals on how they want to regulate AI in the European Union. They want it for there always to be human agency and oversight. And some pretty heavyweight people have weighed in and recommended that we place a total ban on development of AI until we appreciate and understand some of the implications of what's coming our way, in particular with regard to this first point, human agency and oversight, that AI is not going to turn against us in a kind of Terminator kind of way, that there's technical robustness and safety, that the AI, whatever tools are being used, comply with privacy and data governance rules. That there is transparency regarding sources of AI, how it's used, what the output is. That it promotes diversity, that it is not discriminatory towards individuals, that it applies fairly to people. That it contributes to social and environmental well-being, and that the responsible parties in the production and distribution of AI will retain accountability. So that looks like a pretty good set of guidelines for the future of AI. Let's talk about questions. Anything? No? I know,
Well, I'll ask you a
go.
question.
I know you had a few.
I'm only going to read one, but I'll first disclose I didn't know what to ask you, so I went on ChatGPT and it generated 2 pages of questions in 1 second.
Yeah.
Pretty incredible. But my question is on disclosure and being in an A&E firm, like what level of detail would we need to go into on how we used AI in our process?
I don't think you have to go into great detail, just some disclosure. We will use, and I would spin it. I would say we're using artificial intelligence as a tool to enhance our efficiency, and you might give a brief description of how it's actually being used. But I think that would be sufficient. Yeah.
This may come as a surprise to you all, but I use ChatGPT to come up with some of my quips. So it wasn't just coming from me.
Yeah, okay.
Well, I'll ask one more question on that. As far as policies go, is the insurance industry looking to add a policy for use of things like AI for A&E firms?
There are cyber liability policies, and that is a rapidly evolving field. Short answer is there's nothing special right now that I'm aware of anyway, targeting artificial intelligence. If you are in the business of developing software, then you need a tech E&O type policy, is what I would say. If you're using it, your professional liability, your architects and engineers policy itself should be sufficient. But that does lead to an interesting point. Professional liability policies have an exclusion for products. If you're developing something for mass sale, that's a product, it's not going to be covered. But most policies will cover the development of software for an application-specific use, like your HVAC systems or whatever. If it's unique to that application, then it should be part of your covered services. Other questions? Yeah, hi.
What softwares are out there to predict that you use artificial intelligence? I heard some students at university are using it, but their professors are catching them because they have softwares that are using that.
There's a whole cat and mouse game that's going on right now. There's software, yes, that looks for the use of AI-generated content, in particular in generating cover letters and resumes. So, of course, now there's software that will change the AI output to disguise it and make it not look like AI output.
Yeah, because there is another AI-like add-on that can use previous text that you have written, and then they use your style to write that.
Right.
But how, because I know they need it because the student needs to do their own work, all of that. But I have read some articles where at the top they will say this blog post, 68% of the text was generated by AI.
Wow.
So I have seen that around, and I'm wondering if you have any recommendations on that. I would like to use it as well.
Well, if you're in a situation where you're applying for employment, I would say, to the extent you can, don't use it, or look at the first output and rewrite it, because I don't know exactly how these works, and there is the black box problem that even the people who write this code can't fully explain how the output happens. But we do know that there is software that looks for AI-generated content and will flag it, and so the only way that I know to get around that right now is to just not use AI. In fact, this reminds me of a joke I saw a long time ago, which it had to do with outsourcing, but it could apply to AI. And the idea was, I just found somebody in another country who's doing my job. I outsourced my own job, and I'm paying him 30%, and now of what I make, and now I'm getting a new job. And the guy asked, well, doesn't your boss figure this out? And he goes, nah, I tell the guy to screw up once a week, and so my boss hasn't noticed anything. So. Put a typo in. There, you fool them.
All right, Farzan, last question.
Yeah.
I'm just curious if maybe this is obvious or it's still kind of working its way through the court system, but do you think that the ultimate model will be that AI has no access to data to train, et cetera, unless it's subject to some license and affirmative permission, or that it would be the inverse, that you can train it on any public, any web-based data, unless there's some sort of a registry where the owners of that IP have opted out?
until there's regulation to the effect that AI can only be trained on licensed outputs, that's not it. And I don't think it's going to go that way. The decisions we've seen on fair use have surprised me to the extent that they have allowed companies like Google to just take the programming code of Oracle, their APIs, and incorporate them. I don't know why they did that, but they did that. So I don't think it's going to go that way. Yeah.
Thank you so much for your time, Mark.
Thank you, everybody, for your attention. Appreciate it.
Wonderful.